Mr. Ashford,
Yes, sir.
what's that on your head, sir?
It's off, Mr. King.
Mr. Wallace. Mr. Wallace.
Yes, Judge. How are you?
Good morning, sir. What can I do for you?
I'm here on Benny Carter.
Yeah, I'm joining.
Carter. Okay. Do I have the APA here on Carter?
I'm here, Judge.
Okay. We're waiting on Carter.
Case number 2405-740401. People of the state of Michigan versus Benny Carter Jr. Defendant is charged in count 1, homicide, murder, first degree premeditated. Count. Count 3, weapons stolen, firearms, third offense. Defendant has a habitual offender, fourth offense notice.
For the record, please.
Good morning, Your Honor. My name is James Kehoe. My P number is 82812 on behalf of the people.
Good morning, Your Honor. Good morning to your staff. My name is Ted Wallace, P80922, and I represent Mr. Carter. I don't know if he's present by Zoom, but if he is not, I would ask the court to waive his presence for today's hearing only.
So waive the defendant's presence. What's your pleasure?
Your Honor, we're just looking for a preliminary exam date.
The court will continue to plead not guilty and set this matter for preliminary examination. How's June 11th at 10 o'clock.
That's not a good date for me, Your Honor. Let me see. You know what? I can make that work. June 11th at 10 o'clock.
Yes, sir.
Okay.
Is that a good date for the people?
That is, Judge. I just have two other matters to place on the record when the court's ready.
Go ahead.
So first, there's an amended complaint, Judge. For whatever reason, the PAC code for felon in possession is not working on PBK, so I have to do it manually. So I'm going to send that to the court. I've provided it
They
as part of.
changed the statute.
Yes, Judge. And so for whatever reason, we can't actually put that in on our end. So I have to manually do it. And I'm sending that to the court this morning for the court's file. And I've sent it to Mr. Wallace already as part of discovery. And secondly, Judge, there is a protective order I've sent to the court. I just asked that the court enter it for the remaining discovery, Judge.
All right.
So just so the Mr. Wallace knows, there's 4 counts, count 2 being the FIP and count 4 being another felony firearm.
Understood.
Thank you, Judge.
Okay. All right, thank you.
All right, we're all set, Your Honor?
Yes, sir, you're all set. Thank you.
Thank you.
Mr. Gura.
Good morning, Your Honor.
Good morning. What can I do for you?
I am here on Jovan Jones.
Calling case number 2405-738401. People of the state of Michigan versus Jovan Jones. Defendant is charged in count 1, assault with dangerous weapon, count 2, weapons stolen, firearm, count 3, domestic violence.
Good
morning. Good morning, Jessica Davidoff for the people, standing in for the APA record, Shelley Drain, P86743.
Good morning, Your Honor. Alyssa Sarah with the Neighborhood Defender Service on behalf of Jovan Jones, P86432. I believe Mr. Jones is on the Zoom. Mr. Jones, if you can hear us, if you could unmute your device and state your name for the record.
Unmute yourself, Mr. Jones. He seems to be having some problems there. What's your pleasure, Mr. Gura?
I will set this for an in-person preliminary examination, Your Honor.
How is June 10th at 9:15?
That works.
Okay, June 5th at 9:15, June 10th at 9:15, bond will be continued.
Your Honor, if I could address bond. It's my understanding that Mr. Jones is on house arrest. And
So house arrest, how's he driving around?
I believe he's, or his other hours are restricting him from going to work and school. And so I was just going,
Going now.
I'm sorry.
Where's he going right now? It looks like he's in the car.
He has 3 young children, so I'm not sure if he's moving, but possibly taking his kids to school. I'm not, I don't know exactly, but I do know he has young children. That's a possibility. But it's fine. We will address it at the preliminary examination if needed.
All right, bond will be continued. Thank you.
Thank you.
Thank you, Judge.
Mr. Dupree.
Good morning, Your Honor.
Good morning, sir. What can I do for you?
I have Jalen Amerson.
Calling case number 2405-702101, people of the state of Michigan versus Jaden Amerson. Defendant is charged in count 1, assault with intent to do great bodily harm, less than murder by strangulation. Count 2, malicious destruction of personal property, 1,000 or more but less than 20,000. Count 3, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Jessica Davidoff for the people, P86743, standing in for the AP of record, Shelley Drain.
And good morning, Your Honor. May it please the court, Matthew Dupree, P80132, attorney for Mr. Amerson, who is presently in federal custody, I believe being held at the Sanilac County Jail. I'd ask that the court would waive his appearance.
For the way the defendant's presence, what's your pleasure?
Judge, I would ask that this matter be set for preliminary examination. I will say that the Third Circuit Court has already writted Mr. Amerson from Sanilac County Jail, and I'm just finding the dates when he's going to be in Wayne County. I don't know if this court just wants to do its own writ, or I think he's going to be here for about a week. So if we scheduled, we might be able to just piggyback off of Third Circuit's writ, if that makes sense.
Probably should do one as well.
Okay. In that
Here.
case, Judge, what date are you guys looking at scheduling exams?
What date is he going to be here?
So it looks like they're going to be bringing him over on the 18th. And then his Third Circuit hearing is on the 25th. And they're going to take him back directly after that hearing.
So he's going to be here on the 18th.
That's when they would be going to get him, Judge. I don't know that he would be in the jail at 8:30 on the 18th to be brought to court.
We're closed on the 19th for Juneteenth. The 20th is a homicide day. How about the 21st?
I can make the 21st work. Although I could probably make the 21st work, Judge, though I wonder if the 24th is
The 24th is what?
available.
No, that's my homicide day.
That's right. I forgot you have a lot of homicide days. The 21st is good, Judge. Could it be later in the morning if at all possible?
June 21st at 11:30.
Perfect. Thank you, Judge.
June 21st at 11:30. Bond will be continued.
Thank you, Your Honor.
Thank you, Your Honor.
Ms. David, or wait, who was the prosecutor on this? I missed it.
I'm standing in for APA Drain.
Maybe Adrian. Right. I'll email Ms. Train. Thank you.
Welcome.
Mr. Mike Grady. Mike Grady going once. Mr. Mike Grady going twice. I was about to call Mr. Cripps, he stepped out. Mr. Gagnon.
Good morning, sir. I'm with Charles Ashford.
Okay.
Calling case number 2405-739901. People of the state of Michigan versus Charles Ashford. Defendant is charged in count 1 with intent to do great bodily harm, less than murder, like strangulation. Count 2.
You're next, Mr. Cripps.
Domestic violence. Defendant has a habitual offender or defense notice.
Appearances for the record, please.
Good morning, Jessica Davidoff for the people, P86743, standing in for the AP of record, Shelley Drain.
Brian Gagnick, Your Honor, Neighborhood Defender Service, P64220. Mr. Ashford, state your name, please.
Charles Alfonso Ashford.
Your Honor, would the court set us a preliminary exam, please?
I can accommodate you. How's June 10th at 9:30?
I accept.
June 10th at 9:30, bond will be continued.
Your Honor, is there any chance to give him hours on his tether for work purposes? He does have a job, but he has lost his scheduling on that job, so he needs to rearrange with his place of work. Just standard daytime hours if possible.
What do you mean he lost his hours?
Mr. Ashford, you're no longer on the schedule at your work. Is that correct because of this? Because your inability to go to work?
Yeah, my ability to go to work. I've been working at the job since 2020, since I've been home.
Since you've been home from where?
When I
He
came
had a
home
long vacation, Your Honor.
Sounds like prison.
It very well could have been, sir.
yes, sir. It was prison, sir. But I have been working this same job since I've been home 2020. So it's like me doing a no call, no show that I'm technically off the schedule, and I still have to take care of two little girls that I have. I have a 3-year-old and a 5-month-old.
They live with you?
I would you say, sir?
They live with you?
No, they currently stay with my baby mother, but it's other ways. I can have my mother always bring them the stuff for me to them, because I'm at my mother's house now currently.
So I'm thinking, get back on the schedule. How do you get back on the schedule?
Basically, I would let them know that I was incarcerated, and then hopefully they can put me back on the schedule so I can work. If not, that means I have to be in the midst of looking for another job, which is going to be easy for me because I have a very good long background track of me working in factories on 22 Mile in Chesterfield.
So why can't you just have them put you back on the schedule and then I can?
I've been trying to, but it's like it's like a waiting process with them. But it's like maybe they see my face, like, look, I'm trying to come back to work. I still have to take care of my kids. I've been at this job for a very long time now.
When you get back on the schedule, then I will adjust your tethering hours.
Okay.
All right. But you're gonna have to verify that you are in fact working.
Yes, but if I can't get back on the tethering, if I lost my job, is it in a way that I can find a way to get another job, like as in like get hours so I can find another job at least?
Mr. Ashford, I believe the court, if you have a job, I believe the court would listen to an argument for hours on the tether.
Okay.
I have nothing further, Your Honor. Thank you.
All right, fine, continue. Thank you. Mr. Cripps.
Good morning.
If you're on turn.
Yes, we'll make sure.
Who's your APA?
Good morning, Your Honor. It's me, Miss Kurt.
Yes.
Okay. Yes.
Two prosecutors, I think Mr. Kirk's the main prosecutor.
Case number 2305-881501. It was at Michigan versus Will Turner. Defendant is charged in count 1, homicide, murder, second degree.
Appearances for the record, please.
Good morning, Your Honor. Bryn Kurt on behalf of the people, P84009.
And good morning, Judge David Cripps, P34972, appearing on behalf of Wilma Turner. Ms. Turner is on bond and she's knows to be here at 1:30.
Okay, so why are we here this morning?
Judge, I don't believe that the prosecution's ready to proceed on this case. There's not an autopsy report. So rather than wait till 1:30, I thought it was best to bring it to your attention this
Ms.
morning.
Kirk?
Your Honor, Ms. Moynihan and myself were preparing the preliminary exam yesterday, Your Honor. And when we called to figure out where the autopsy report was, it hadn't been completed yet. We were informed by Dr. Sung that it could be completed and would be sent over to us yesterday. We did reach out to Mr. Cripps, I believe Ms. Moynihan did. And, you know, we had all realized at the same time yesterday that we didn't have it. It was sent to our inbox this morning, Your Honor, maybe 5 minutes ago. But the people would ask for a brief adjournment to allow for the autopsy report to be sent over to Mr. Cripps and allow him to have time to review it.
Why can't you do that now, between now and 1:30? Hello?
I can of course send it over right now, Your Honor. I make sure that nothing needs to be redacted and get it over to Mr. Cripps. But I'll leave anything else in your discretion, Your Honor.
Is the report done or not? That's right. Don't
She
understand.
said they have it, they got it this morning. I'm wondering why she can't get that to you now.
And I can.
Okay. All right, so I'll see you guys at 1:30.
There was also an issue that a motion was filed yesterday to omit out-of-court statements. Just getting it yesterday, I haven't been able to respond in writing. I can respond orally at 1:30. If that's okay with the board.
Yeah, that's fine. All right, I'll see you guys at 1:30.
Could you please send that as soon as possible so I can read it at lunchtime?
Yes, you'll have it within the next 10 to 15 minutes.
Thank you, Honor.
All right, thank you. Ms. Marsh?
Good morning, Judge. I have Marcus Gordon.
Okay.
Calling case number 2405-740201, USA, Michigan versus Marcus Gordon. Defendant is charged in count 1, domestic violence, third offense number.
Appearances for the record, please. Jessica, are you there?
Hi, Judge. Sorry, I'm operating from my phone. That's my bad.
Ms. Gordon, appearance for the record, please.
Marcus
Jessica-
Gordon. Oh, I'm sorry.
Jessica Davidoff for the people, P86743, standing in for the APA record, Shelley Drain.
Carolyn Chapman Marsh, P31887, on behalf of Mr. Gordon, who is appearing via Zoom with consent. Thank you, Your Honor.
Tell us your name, Mr. Gordon.
Marcus Amir Gordon.
What's your pleasure, Ms. Marsh?
Yes, Your Honor, we would like to schedule this for an in-person preliminary examination.
Court will continue the plea of not guilty and set this matter for preliminary examination. How's June 10th at 10 o'clock?
Do you have anything a little bit later, Judge? I have a couple of sentencings over in Wayne County.
11:30?
That's a good time. Thank you, Judge.
June 10th at 11:30, bond will be continued.
Your Honor, I would like to discuss Mr. Gordon's tether hours. He is employed, and I think the tether hours were trying to accommodate his work. However, they're daytime tether hours, and he works the afternoon shift. I think it's tether hours. Mr. Gordon, tell the court what your tether hours are currently.
The current hours are 12 a.m. to 1 p.m. that I'm allowed to be out. They were supposed to be to accommodate the hours of me work from 3 p.m. to 11 p.m.
So they're like reverse, Judge. So we would ask the tether hours to be changed to 2 o'clock to give him time to get to work to midnight.
You work from 3 to 11, sir?
Yes,
Where do you work?
for a motor company, been almost 10 years.
Which plant?
The Dearborn Rouge Complex, DDMP.
Local 600?
Yes,
You've been there 10 years?
almost, it'll be 10 years next February.
Who's your president over there now?
In the building or over the local?
The local.
What's his name? Oh, I forget his name. He just got in there. I'm not sure of his name, but I know over our building is all that has changed. I forget his name. Just Tony Rich, that's his name. That's over the local.
Tony Richards. Okay.
Yeah.
I was just testing you.
Oh, yeah, I'm there. I got my jacket on.
Okay, I see. All right. Send me over a proposed order to that effect, Ms. Marsh.
Thank you, Judge. I will do that.
I do from 2:30 to 11:30.
Thank you, Your Honor.
Okay, thank you.
All right, Mr. Gordon, I'll talk to you soon.
This is Mike Grady. I'm sorry.
I said the 2:30. That's, I don't know. That's kind of cutting it close to South.
It doesn't take you the hour to get to work, does it?
No, but I said South always have a lot of traffic going to work. There's always a lot of traffic on Rotunda. They're doing construction over there.
Yeah, the traffic is usually going north, though, not south.
No, it's just construction going south. On Southfield, it is construction on Rotunda going east.
All right. We'll do the 2 o'clock to 11:30.
Thank you, Judge.
Okay. Mr. Mike Grady, you ready now?
I am, Your Honor, yes, and I apologize.
Who you
Different
here
Zoom. I'm Ronell AG.
Calling case number 2405-740501. People of the state of Michigan versus Ronell AG. Defendant is charged in count 1, weapons, firearm, possession by a prohibited person. Counts 2 and 3, assault with a dangerous weapon. Counts 4, 5, and 6, weapons, felony firearm. Count 7, domestic violence. Defendant has a domestic violence second offense notice and a habitual offender third offense.
Appearances for the record, please.
Good morning, Your Honor. Jessica Davidoff for the people, P86743, standing in for the AP of record, Shelley Drain.
And good morning, Neighborhood Defender Service by Kate DeMott Grady, P83667, on behalf of Mr. Ronell AG, who joins us via Zoom. Mr. AG, please state your name.
Ronell AG.
What's the pleasure, counsel?
Your Honor, I'm requesting digital discovery and a preliminary examination date.
How's June 10th at 10 o'clock?
That works for defense.
June 10th at 10 o'clock. Bond will be continued.
Thank you. And Your Honor, may I address bond?
Okay.
Mr. AG's tether hours are currently 9 p.m. His curfew is from 9 p.m. till 6 a.m. Mr. AG works for Forge Staffing, and sometimes he has the option to pick up night shifts. So it's like a staffing agency that's getting shifts that they need people to fill in for. Sometimes it's overnight shift. He can't pick up any shifts because of the tether hours. So I'm requesting
pick up shifts during the time that he's not on those restrictions.
Your Honor, sometimes there's only third shift is the only one available is what he's relaying to me. So he's attempting to work. Now we're not asking to remove the tether. We're just asking to amend the hours so he has the flexibility to work.
And he's gonna have to have something more permanent. Or he has a set schedule.
At this point, Mr. AG, you don't have a set schedule. Is that right?
Yeah, once I called, they set me on a schedule as soon as I called.
Your Honor, I'll
Yeah,
work
as
with
soon as I
court
call-
staffing to see what documentation I can get, and then I can reach out to the prosecutor and submit something to the court.
Okay, that's fine.
The other thing that I'd just like to note is Mr. AG, so the complainant in this case is his wife. He is living separately with his brother. He understands he can't go back to that address. However, his vehicle is there. His car is there with the keys. He would like to get his car. I advise that he should ask for a police escort. Obviously, I wanted to let the people know that and the court know. If there's anything else the court would like me to do to help facilitate that, but I just wanted the court to know that he is seeking to get his vehicle back from the address he's not allowed to go to.
So how's he gonna establish that this is his vehicle?
Your Honor, I believe it's registered to him, so if we can, the police, can double check the paperwork. The police know that it's registered to him, is my understanding.
They saw me get it. They asked me, did I want to get it?
Just so long as he has no contact with her unless he has the police with him.
Understood.
Okay. Mr. Lamb.
Hello.
Good morning, Judge King.
Good morning, sir. What can I do for you?
I'm here for Mr. Lauderdale, set for an exam. He's in custody.
Did you want to wait on him or waive his presence?
I would waive his presence. It's my intent to request a competency evaluation for Mr. Lauderdale.
All right. Do I have it? Let's give this card right.
It is, Judge.
Okay. Calling case number 2405-741501. State Michigan, this is Michael Lauderdale. Defendant is charged in counts 1 through 4 criminal sexual conduct, first degree. Count 5, kidnapping. Count 6, robbery armed. Count 7, criminal sexual conduct, second degree. Count 8, assault with intention to break bodily harm, less than murder or by strangulation. Count 9, motor vehicle, unlawful driving away. Count 10, assault with a dangerous weapon. Count 11, police officer fleeing, fourth degree vehicle code. Count 12, criminal sexual conduct, second degree. Count defendant has a second or subsequent offense notice and a habitual offense notice, mandatory 25-year sentence.
Appearances for the record, please.
Good morning, Your Honor. And Cartwright on behalf of the people, P82411.
Good morning, Your Honor. Michael Lamb, P79816, appearing on behalf of Mr. Lauderdale. I will respectfully request that his appearance be waived and that he's in Wayne County Jail at this time.
Before the waive the defendant's presence, what's your pleasure?
Your Honor, I've had the opportunity to speak to my client. At this time, I believe that it is appropriate to refer him for a competency evaluation.
Why is that?
Well, first and foremost, he requested such. And secondly, just based on my observations of him, his responses to some of my questions, the facts and circumstances surrounding the case, I believe that it is appropriate to have him evaluated by the Forensic Center.
You said he requested one?
He did.
That's interesting.
And Judge, the people would agree based on all of the circumstances and speaking and to the complaining witness.
All right, the court will refer the defendant for a competency evaluation to be performed by the Forensic Center. We'll set a review date for September 4th, 2024 at 8:30.
September 4th at 8:30?
Yes, sir.
Understood. Thank you.
Thank you, Your Honor.
So that's it for the probable cause conferences. We are down to 1:30. No, you still have Jacob, I'm sorry. It's hot.
Judge,
Yes,
I get to be your courtroom APA for a day on June 14th again.
okay, always happy to have you.
I'm always happy to be there, Judge.
Did great today, thumbs up.
Thanks, thanks. We have one left, correct?
Yes. Terrence Jacobs.
Okay.
And Mr. Jacobs is with us from the Wayne County Jail. We're just waiting on your attorney, sir.
All right, I'll sit tight. I'll be around.
Okay.
Well, for court case. No. It's too much work.
Just to say hi. You're in 234.
Yes.
Okay. All right.
Little Asian.
16. 10.
Yeah. Good morning, Ms. Hines.
Good morning, Judge. How are you?
Good, you're here on Jacobs.
Yes.
Calling case number 2405-741601, Douglas State, Michigan versus Terrence Jacobs II. Defendant is charged in count 1, assault with a dangerous weapon, count 2, domestic violence.
Appearances for the record, please.
Jessica Davidoff for the people, P86743, standing in for the APA record, Shelley Drain.
Good morning, Your Honor. Brianna Hines, P87456, on behalf of Mr. Terrence Jacobs.
And Mr. Jacobs, tell us your name for the record.
Jerome Jacobs II.
And what's your pleasure, counsel?
Yes, Your Honor, we are looking to set for a preliminary exam, and we also are missing all video discovery in this case.
Regarding discovery, Your Honor, APA Drain filled me in and said that there wasn't a attorney assigned at the time she was sending out discovery, but now that we know that it is Ms. Hines, we will be sending out discovery.
Court will continue to plea of not guilty and set this matter for preliminary examination. How is June 10th at 10:15?
That works, Judge.
Okay. June 10th at 10:15, bond will continue.
Thank you, Your Honor.
Thank you, Your Honor. Mr. Jacobs, I'll be visiting you later today.
Okay.
Okay. Thank you.
Have a nice day, Judge. I'll see you on June 14th.
All right, have a great one. Thank you.
Judge, is the APA still on?
No, they're done.
That was a victim on AG. She said there'd been numerous contacts. Just want to let the prosecutor.
AG?
Yes, sir. I told her to call the prosecutor's office.
What do you mean as far as the person was examined?
Yeah, turn to 60. But no, whatever.
Okay. Calling case 2358815, people of the state of Michigan versus Rumel Latrice Turner. Defendant is charged in count 1 homicide, murder, second degree. Appearances for the record, please.
Good afternoon, Your Honor. Brayden Hurt on behalf of the people, P84009. And good afternoon, Your Honor. Tina Whitehead on behalf of the people, P84692.
Good afternoon, Judge David Brooks, P34972, appearing on behalf of my client Wilma Latrice Turner. Tell the judge your name, please.
Wilma Latrice Turner.
There's the date time set for preliminary examination. Are you ready to proceed?
Yes, Your Honor. Look, here to proceed.
How many witnesses will there be?
3 to 4.
Each preliminary matters before the party, please.
I make a motion to sequester the witnesses.
Your Honor, the people were joined in that, and the people also yesterday filed a notice for 804B6 that I believe the court might be on prior to proceeding.
First thing first, ladies and gentlemen in the courtroom, if you are a witness or potential witness, I'm asking you to step into the hallway and to further notice. Also, ladies and gentlemen out there in YouTube land, if you are a witness or potential witness, I'm ordering you logged off at this time. This relates to the motion.
The people would express that motion.
Judge, I just received this motion yesterday. I wasn't able to do a response. I was going to do something late in the morning, but the internet is out at the office.
Okay, you can address it.
Yeah. And I just, I now have the autopsy. This motion is an extraordinary one that should be denied. My client is charged, obviously, with second-degree murder, and this involves an incident that occurred on August 21st, 2023, where there's allegations that my client stabbed another person after there was a lot of drinking, loud argument, and a spontaneous stabbing occurred one time. That's why she charges our second-degree murder. Now, the deceased in this case a person by the name of Cliff Lipkovich, at Lipkovitch, and I hope I'm pronouncing it right. This person who was stabbed, he was stabbed on August 21st, but he did not pass away until 3 days later, August 24th. That's a 3-day time period in which he survived. What the as I understand it, what the prosecution is attempting to do is to put in the evidence. It's not really clear exactly from the pleading what exactly they're putting in the evidence, but some sort of statement made by the deceased to the police on August 21st, which they interviewed him and he answered the questions. The way that they're trying to get this into evidence, I don't think is appropriate because they're trying to get this in under Michigan Rule of Evidence 804B6. And even looking at the case that was cited in the pleading, People versus Burns, found at 494 Michigan, page 104, 2013 Michigan Supreme Court case. That case tells us that it's not admissible as to what they're trying to do. In that case, there was a reversal of a conviction because the trial court allowed in a statement that under the guise of forfeiture by wrongdoing, and that's what this rule of evidence is known by, is forfeiture by wrongdoing, because the prosecution failed to demonstrate that the defendant had a specific intent and in fact did cause the unavailability of declarants of a witness. But now what has to be shown under that case is three different things. That number one, that the defendant engaged in or encouraged wrongdoing. Okay, well, she allegedly engaged in wrongdoing. That's what we're quote on. But two, that the wrongdoing was intended to procure the declarant unavailability. And number three, that the wrongdoing did procure the unavailability. And the decision it refers to a United States Supreme Court case, U.S. versus Giles, at 554 U.S. 367, Supreme Court case, U.S. Supreme Court case, that says that within this rule of evidence, it incorporates a specific intent requirement. It requires the defendant must have engaged in or encouraged wrongdoing that was intended to and did procure the unavailability of a witness. In other words, reading this decision, what I understand it means, it's not just the fact that somebody may have killed someone else that satisfies the statute for forfeiture by wrongdoing. There also has to be a showing to the preponderance evidence that was specifically done to prevent their testimony later.
So my take on that statute has always been that it applies to where you have a defendant who, for whatever reason, discourages someone from testifying or does something so they don't are unable to testify with the specific intent for them not to testify. I'm going to kill this person so they don't testify. That was my understanding, my interpretation of that statute.
You have the correct interpretation. It's exactly what the Michigan Supreme Court says. The prosecution based on the pleading, seems to think they can just stand on the fact that, oh, we showed that we believe we're going to be able to show that this term would cause a death. Therefore, that's forfeiture by wrongdoing. And I object to that, Judge.
Well, Your Honor, here we do have an intent to kill. The intent to kill for the murder in the second degree does intend to prevent him from being available to testify as to who did the stabbing. If not for her actions of stabbing him, as the people allege, he would be here to testify about what happened. Therefore, she did intend by stabbing him and stabbing him with the intent to kill, just without premeditation.
Well, you may very well have an intent to kill, but you have an intent. See, my interpretation of again that statute is that it's intended for the purpose of preventing a witness to come forth, the specific intent to prevent that witness from coming forth to testify. That is not what I understand what you're trying to do. That's not the intent behind that statute.
Let me have a moment. We understand the first one. Thank you, Your Honor.
That being said, are we ready to proceed now?
Yes.
Call your witness.
Your Honor, at this time, the people would call Officer Stephen Jackson.
Sir, please step forward, give your name and spelling to the court reporter seated over there. Please raise your right hand, sir. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. Please have a seat with your remarks. Speaking to that microphone, that would be to your left. Maybe getting you ready.
Officer, could you please state your name again for the record, please?
Officer Stefan Jackson, badge 2158,
And Officer Jackson, how are you currently employed?
Detroit Police Department,
How long have you been employed with the Detroit Police Department?
a little over 2 years.
Were you employed and working for the Detroit Police Department on August 21st, 2023?
Yes, ma'am.
Were you by yourself or with a partner?
With the partner,
What's your partner's name?
Officer Mr.
Could you spell Nister for me?
NISTOR,
And were you an officer Nister on foot or in a scout car?
in a scout car,
Was that scout car fully or semi-marked?
semi-marked.
What is a semi-marked police car look like?
So it's a black car with Detroit Police brand on it, but it's like, it's visible, but it's like, it's hard to explain.
It is not in a high contrast, would that be fair to
Yes,
explain it? Okay. And were you in full or modified uniforms?
modified, fully modified uniform. Either Class C uniforms.
Another person just came in, I don't know if you're just.
Oh, I see. I'm sorry. He's the officer in charge of the case, and have an exception for the witness.
Your Honor, there's always an exception for the officer in charge.
But not always, it depends on whether, I'd like to know when it was testifying, not part of the process.
The officer testified to.
No.
Okay, we'll get.
Can you please describe what a Class C uniform looks like?
It's a black shirt with green pants.
Does it have a badge or any identifiers on it that would identify you as a Detroit police officer?
It has my name and badge on there, as well as the Detroit Police Department badge on there as well.
You have your duty belt, which includes everything that you need to be an on-duty officer. It's foundational. Can you answer my question?
Yes, ma'am.
Were you wearing a body worn camera?
Yes, ma'am.
Do you know if your body worn camera was on and operational?
I believe it was.
If I were to show it to you, would you recognize it?
Yes,
All right. So, officer, on August 21st, 2023, did you have the opportunity to go to 15,535 Harbor Avenue?
Yes, ma'am.
Is that here in the city of Detroit, County of Wayne?
Yes, ma'am.
What, if any, why did you go to that location?
It's a police run for a Saturday.
And do you recall around what time of day it was?
I don't recall. It was really morning, like late afternoon, maybe early morning.
Did you say morning or afternoon?
It was early, like late morning, early afternoon.
And when you arrived, what, if anything, did you do first?
As soon as we arrived, we were.
So, officer, I'm going to stop you there. I know you and Officer Mister worked in close tandem and you are partners. And what you did, he probably did too, but I do need you to specify for me what you did and what you observed specifically, okay?
When I arrived, the second story, there was a group of individuals playing as to how to explain that somebody was stabbed on the second
Objection
story.
as to hearsay.
Not being offered for the truth of the matter, asserted but for the effect on the listener.
I'll take it.
Now, upon being flagged down, what, if anything, did you do?
We went to the second story of the apartment building where we met the victim who explained that he was stabbed.
Objection as to hearsay, Hunter.
I'll lay some more foundation. Now, when you spoke to the individual upstairs that you, did you observe anyone with any apparent injuries?
Yes, ma'am.
Did you speak to this person?
Yes, ma'am.
Did you speak to this person about how they came about their injuries?
Yes, ma'am.
Did they provide any specific identifiers about?
Objection as to leading. The question is, supplies the content.
Did the person that you observed to be injured provide you with any specific identifiers or relationship to the person that allegedly stabbed?
Objection is to leave, Your Honor. That's putting words into his mouth in terms of what was said or not said. And it's hearsay.
Your Honor, I'm laying the foundation for exception under 27C, which does allow for a police officer to testify to hearsay as long as certain elements are met. Those elements are that it is close to time to the incident, 5 years post-incident, that it is to a police officer, which he's already testified that he is. If they are reporting incidents that could have caused or did cause harm to themselves, which indicated that he was speaking to the person that had an apparent stab wound, and if they're reporting to provide information in relation to a domestic violence incident, which is where I'm laying the foundation for, Your Honor. And it's not hearsay. And if it is hearsay, it is allowable hearsay for foundational purposes under 27C.
Judge, it's a response to police question. We don't even have the identity of the speaker. He's talking to somebody, and now he's all ready to start giving hearsay based on questioning of the person at the scene.
Did you get that person's name, sir?
Yes, sir.
What was the name?
His first name, is it okay if I read my report?
Would that refresh your recollection?
Yes, ma'am.
Do you have your report on you?
I do. His last name, sorry.
Okay, do you recall his first name?
Can you
But
spell the names for us?
reviewing your report would refresh your recollection?
Yes, ma'am.
Your Honor, may the witness review the report?
Yes.
Please do so. Look at the
His name was Cliff Lipkovich.
And you observed an injury on Mr. Lipkovich.
Judge, I think there's no foundation as to how he got that. There's no foundation as to how he got the name in his police report.
I got the name from him when I was speaking to him about his injury, sir.
And again, this would be in response to a question by this officer.
Identification.
It's also in my bio here, too, sir.
All right, so, officer, you spoke to Cliff Lipkovich.
Yes, ma'am.
And you observed Cliff Lipkovich to have an apparent injury.
Yes, ma'am.
How did you have observed an apparent injury on him?
He was holding his lower abdomen area. He removed both of his hands, explaining that he was stabbed.
Objection as to hearsay, going beyond identity.
I'll move on. Did you happen to observe an actual injury on this person?
Yes, ma'am. I observed this is part of his intestines sticking out of his stomach.
And would you recognize a still shot from your body worn camera prior to show to you?
Yes, ma'am.
Let the record reflect that I am approaching from the council with people's proposed one.
Thank you.
Permission to approach?
Yes.
Officer, do you recognize what I just handed you?
Yes, ma'am.
What is it?
This is a picture of my body on camera, time of the incident.
And does it appear to have been changed or altered in any way?
No, ma'am.
Is it a fair and accurate representation of the scene as you saw it on that day?
Yes, ma'am.
Ground permission, no. People move for the admission of people's proposed one.
But my only objection would be, he said at the time of the incident, I don't think he testified he was there at the time of this incident.
Yes, it is,
He
sir.
gave- Excuse me, sir, addressing the judge. I don't think he was there at the time this incident occurred. If it wants to be corrected at the time that he spoke with him, then I wouldn't object to that foundation.
Officer, were you present for the actual alleged incident?
No, ma'am.
Is this still from your body worn camera from when you arrived on the scene to take and do your job as a police officer?
Yes, ma'am.
People move the admission of people's proposed one.
Any objection?
No, Your Honor.
Admitted?
So officer, the person whose full body we see standing up in the white shirt, who is that?
That would be
Mr.
Mr. Lipkovich.
And he is as you saw him on that day.
Yes, ma'am.
Could you describe for me where you observed the injury on his body?
Here's the end, right, lower abdomen.
And what, if anything, special did you note about that injury?
That when he lifted up his shirt, his arms, his shoulders, I think was
Objection as to speculation. Listen,
Your Honor, a lay person can identify various emotions just based on their average everyday interactions with people. Being able to identify that someone is in pain from a very obvious stab wound is not.
Never see.
Thank you, Your Honor. Permission to publish the photos in the court.
Yes. Let me see that.
So, officer, what if anything, did Mr. Lipovich say about his relationship to the person that might have done this?
objection as to hearsay.
Domestic violence statute allows. Never see.
At the time, when I asked him about the relationship, he explained that he was in a lot of pain and to ask one of the witnesses or stuff on site. So, but when I did speak, after I did speak with the witness,
So, the information that you're about to provide to me, did you obtain it from Mr. Lipovich?
yes, part of it, I did.
Did Mr. Lipovich himself tell you how he knew the suspect?
Well, again, it objects to the leading nature of the question. There's been no discussion of what the suspect.
Rephrase.
Did Mr. Lipovich provide to you any indication of how he obtained that?
He explained that he was shot at.
Again, I have an objection.
Objection is noted.
Thank
He
you.
did say that he was shot at by the person who stabbed him prior to the stabbing.
Had you interacted with Mr. Lipovich before?
No, ma'am.
If he at any time tell you his relationship with the person injured.
And he himself did not say his relationship with me. But one of the witnesses did tell him.
Objection again, Your Honor.
Relationship.
Objection. Tell us, direct this officer just to respond and not go on. That's when it's a problem. Yeah.
I got this.
I understand. It's a great thing.
So, officer, can you describe for me what Mr. Lipovich's demeanor was like during that time?
He was in a lot of pain. He was very fatigued during the time.
Did you notice anything else about him, his speech patterns or anything like that?
When I was able to speak with him, he was able to give me some of the story. But towards the end, when he was before the night came, he was very fatigued. Just wanted to relax.
So, did Mr. Lipovich give provide the name of who did this to him?
Yes, ma'am.
What was that name?
Same objection.
Your Honor, Rule 8032, excited utterance. Would indicate that he was under fatigue, tired, under the in pain.
You don't have to necessarily be excited for it to be excited. Excited utterance is a statement that start with events such as physical stuff. It is made by a person while in distress caused by the event. I think it's called.
I don't, it has to be a direct connection to the relationship to the event itself caused by the event.
What, if anything, did you ask Mr. Lipovich?
Before I asked him that, I spoke to the one of the witnesses.
Specifically, Mr. Lipovich.
I
What did you ask him?
I asked him, did the individual that stabbed him shoot at him prior? And he said yes. I asked him to provide a name of the person stabbed and shot at him, which he provided no return.
And what, if anything, did you do after receiving this information?
I relayed it to other officers as well as detective.
And what, if any, now you indicated you spoke to several other people on scene, is that accurate?
That's correct.
How many other people do you say you spoke to on scene aside from Mr. Lipovich?
In regards to on the second story or just in total?
Civilian people in total.
Approximately, maybe 7 or 8, not really sure.
So after you completed your investigation at that address, what, if anything, did you do next?
I went to the location to where the witness is described, Miss Turner to live, along with Detective Townson and my partner. And it's up to locate her. I was not able to come up with something like that.
So you were not able to locate her. Did you engage or participate in any further investigations for this case?
I did.
What, if anything, else did you do?
It was, I believe, either a day or so later, we went to Miss Turner's house again with Detective Townsend.
So I'm gonna take you a step there. So you were there with Detective Townsend, but you said we. Who else were you there with?
Officer Mr. and Corporal Annuity.
Corporal who?
Annuity.
Can you spell Annuity for me?
ANOTUI.
And what, if anything, did you do at this location?
Apprehended this Turner.
Did you see Miss Turner here in the courtroom?
This man.
Could you point her and tell me something that she's wearing?
Straight over here, she's wearing a white t-shirt with red on it.
And let the record reflect that the witnesses identified the defendant.
So no.
People are satisfied. People, no further questions at this time for this witness.
Thank you, Judge. Okay, your officer, Stephen Jackson, is that correct? Stefan Jackson. Is it spelled with a O or an A?
The A, sir.
Okay, but it's still pronounced Stefan.
That's correct.
Thank you. And you said that you went to that location with Victor Nistra,
That's correct.
and did you drive the police car there or were you the passenger?
Passenger seat, sir.
And you were directed to a specific location?
Yes, sir.
And when you arrived at the location, were there any other police officers there already?
Not already, they arrived with us.
So more than one police car arrived at the same time? And you described how you went, was it a residence you went to?
It was an apartment building, sir.
All right, and you said that you went to a upper level of the apartment building, is that correct?
That's correct.
What does that mean, like upstairs?
It was a 2-story and an apartment complex.
Okay. And how did you get up to the second story?
Through the door, sir.
On the first floor?
That's correct.
And was there a stairway that led to the second floor?
That's correct.
And you said you went out on a porch, is that right?
Balcony, sir.
A balcony. Describe the size of that balcony.
It was the length of the building and the second story, sir.
So what would the length of the building be?
That's.
If you don't know, that's fine. I'm
not sure.
Okay. And when you came out onto that porch, was it just you and your partner who were on the porch as far as police officers go?
No, sir.
Was there other officers out there on the porch already?
They were with us. My partner and I were the first ones to arrive, sir. Other officers were assisting behind us.
All right, when you came on the porch, how many people did you see out there?
Maybe a rough number, I don't remember, probably maybe 4 or 5. Maybe. That's just an approximate number, I don't recall fully.
All right. So you saw 4 to 5 people, is that correct?
That's an approximate number.
Did you see like any liquor bottles and things like that laying around?
I don't recall.
Beer bottles, things of that nature?
I don't recall.
You described somebody by the name of Lipkovich, is that right?
Yes, sir.
Where did you see him when you first arrived on the porch?
He was to the the right of the balcony when we went through the door,
Okay, what was he doing?
holding his abdomen area and in pain.
Did he say he was in pain or you just assumed that?
He said that he was in pain, that he was stabbed.
All right, did he also tell you that he didn't want to speak to you because he was in pain?
After, later on down the line, he did say that just to ask the witnesses around the balcony.
Did he tell you, officer, that he didn't want to talk to you because he was in pain?
Yes, sir, he did.
That's all I'm asking. Before that, all you really got out of him, as I heard direct here, is asking who he was. Is that right?
I gathered his name, and then he was able to tell me a suspect's name, or he did say just ask the witnesses for the full story, sir,
Okay. So he really didn't tell you much. He told you to talk to other people.
that were present, sir.
He didn't say who stabbed you.
He did say so.
We did?
Yes, sir.
And what did he say?
William Turner, sir.
That he used that whole name? He didn't give you a nickname?
He, in the body worn camera, you can watch, sir, he did provide.
I know I can, but I'm asking you questions here.
Yes, he did, sir. He provided the name of Wilma.
A name or a nickname?
A name of Wilma Turner.
Did you ask anybody on the porch, are you Wilma Turner?
I did not, sir.
Were there females on the porch?
Yes, sir.
So you don't know if Miss Turner was out there?
I do know, sir, I was able to gather their names as well, and
Okay.
they were witnesses.
All right. Did he tell you that he had a verbal argument with Miss Turner?
I don't know.
May I approach, Your Honor?
You may.
Did you read your report before you took the witness stand?
I did not read my full report, sir.
You knew you were going to testify in a homicide case before the Honorable Kenneth came and didn't bother reading the police report?
Argumentative.
Suspend.
I'm just laying foundation. All right, did you? All right. May I approach, Your Honor? Is this your report, sir?
Yes, sir.
Could you read it over, your own report over? Now I ask you a question.
Which part would you like me to read, sir?
Where is that, where he said he had a verbal argument? Yeah, all right.
I spoke with the victim who explained that.
Objection, Your Honor.
I was asking you to read it over.
Read it to yourself, sir.
Okay. What did you just read? Was it your report? Or
Yes,
I
sir.
assume you didn't put the report together today,
No, I did not.
so it's the same day that the incident occurred, is that correct?
Yes, sir.
Okay, and you got a chance to read it over
Yes, sir.
and to refresh your memory?
Yes, sir.
And do you see where it says that the, Mr. Lipkovich had a verbal argument with Ms. Turner?
Yes, sir.
Thank you. That was before the stabbing occurred.
Yes, sir.
Thank you. Now, did you take somebody into custody other than Ms. Turner initially?
Initially, yes, sir.
And who would that be?
I don't recall her name, sir.
May I approach her?
Yeah.
Does that refresh your memory?
Yes, sir.
And who was it?
Serafina Farmer.
And why did you initially investigate her as a suspect?
Because the description of the last book worn by Ms. Turner was a yellow shirt and blue jeans. So which she was wearing yellow shirt and blue jeans in the area.
Okay. Did you formally arrest her?
No, sir.
Now, you said that Mr. Lipkovich appeared fatigued.
Yes, sir.
And did you smell any alcohol in his breath?
I don't recall, sir.
Did he give any other, or you don't recall whether he smelled alcohol, is that correct?
That's correct, sir.
Did you ask him whether he had been drinking alcohol?
I don't recall, sir.
Did you ask him whether he had been using any drugs?
I don't recall, sir.
Did you take anything into evidence off that porch?
I don't recall, sir.
You said 2 days after this incident, or I don't want to put words in your mouth, how many days after the incident did you go to where Miss Turner?
I went The first time I went on that same day to her house, but to arrest Ms. Turner, it's approximately, I don't recall the exact date, so.
Okay. And if I show you the report, would that refresh your memory?
Yes, sir.
Could you identify this with the judge, please, just what it is?
This is my supplement report to the time that we arrested Ms. Turner.
Is it refresh your memory as to the date?
Yes, sir.
What would that be?
August 22nd.
So you went over to where you believe Ms. Turner lived on August 22nd?
Yes, sir.
And went to the front door of that location?
Yes, sir.
And you were in police uniform?
Yes, sir.
So anybody looking at you would obviously know you're a police officer?
Yes, sir.
And when you were at that location, came to the front door?
I did not go to the front door, sir.
I'm sorry, who did that?
I don't recall, but I went to the after the house. I think Detective Townson was to the front door.
Oh, another police officer?
Yes, sir.
And my client voluntarily walked out the front door?
Not at that location, sir. She volunteered walked out of the location down the street.
Okay, wherever you came into contact with her, she walked out the front door?
I don't recall if it was the front door or the side door, but she walked out of the house voluntarily, sir.
See if your report would refresh your memory again, bottom paragraph, sir.
Yes, sir.
All right, that refresh your memory?
Yes, sir.
When the police went to the location, she walked out the front door to the police, right?
Yes, sir.
Voluntarily, with the police, turn herself in.
Yes, sir.
Thank you. Nothing for this.
Any redirect?
Yes, that's what we excuse.
Thank you, sir. You may stay.
Your Honor, people would call Officer Stephen Townsend as our next witness.
Please give your name and spelling to the court reporter. Please raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you, sir. Please have a seat with us. When you're ready.
Thank you, Your Honor. Can you please state your name for the record?
Stephen Townson,
And how are you currently employed?
Detroit Police
How long have you been employed by the Detroit Police Department?
Department, 16 years.
And were you employed and working on or about August 21st, 2023?
Yes,
Did you have an occasion in your duties as a police officer to go to 15,535 Harbor Avenue here in the city of Detroit, County of Wayne?
yes, I don't know that that address is correct.
If it was listed on the report, would it be accurate?
15,535?
Yes, sir.
Yeah, okay, that is correct. Sorry.
And why did you go there?
There was a police round that came out as a staff.
And you went to the scene in what capacity?
I worked as a investigator at the main precinct detective.
So were you there initially as potentially officer in charge or something else?
Officer in charge.
And when you arrived to the scene, what, if anything, did you observe first?
I observed the victim seated in the chair. Second floor.
And did you make your way up to the second floor of the building?
I did.
Now, this building, was it a residence?
It's an apartment. It's an apartment building. Balcony. It's a two-story apartment building with balconies on the external outside.
And these balconies, were they facing out to the street, inside, internally into the apartment complex or something else?
They face out to Somerset Street. They're on the outside.
So you go up to the second story, and who, if anyone, do you come into contact with first?
Come into contact with the victim, Cliff.
Well, objection, there's no foundation for that for him unless he knows him past you. Well, how would he know who the person is? Name. When he walks on the board.
Somebody identified themselves to you that appeared to be a victim of an alleged assault.
Yes.
Who was that person?
Clifford was coach.
And you got that person's name from that person?
Correct.
Now, did you speak with Mr. Lipkovich on scene?
I did.
Did you speak with him at any other time?
Yes.
When was that?
It was the following day at the senior hospital.
So the following day being August 22nd?
I believe so.
And had you identified yourself to Mr. Lipkovich as a police officer?
I did.
And what was your purpose for going to the hospital?
My purpose was to get a statement from Mr. Lipkovich and make an identification of the person that assaulted him.
And was Mr. Lipkovich awake when you arrived at the hospital?
He was.
Did he appear, do you know if he was under any medications at the time?
I don't.
Did he appear to be alert and able to answer your questions?
He was.
And did he provide you any statements about what, if anything, happened to him?
He did.
Did he tell you what, if any, relation he had to any potential suspects?
Judge, objection, you ruled on this issue in terms of hearsay evidence. And so.
I believe people are again establishing under the court rule that allows witnesses to testify as relates to domestic violence relationships. Am I right?
Yes, Your Honor.
I think that's.
This is the day after the incident, Your Honor.
It doesn't matter when the interview takes place. If it relates to a relationship between the parties. It's that, what is the domestic violence statute?
It is MCL 768.27C, Your Honor.
Who says that?
I did.
Go ahead.
To continue or repeat the statute, Your Honor.
Oh, I thought you were trying to say something else.
Oh, no, Your Honor.
768.7.
27C, Your Honor.
768.7.
27C.
Statement purports to narrate, describe, or explain the infliction of threat or physical injury upon the declarant. The action in which the evidence is offered under this section is an offense involving domestic violence. The statement was made at or near the time of the infliction or threat of physical injury. Evidence in the statement made more than 5 years before the trial. The statement was made under circumstances that indicate the statement's trustworthiness. The statement was made to a law enforcement officer. The purpose of the subsection of these circumstances relevant to the issue of trustworthiness, including or not limited to statements made in confirmation. Anticipate litigation which is interested in a bias or motives of the statement. Statements section. right, so the court again is allowing the 768 and 276.
Could you say that again, Judge? I couldn't.
Court is allowing this testimony in 768 and 27. Sorry?
Which the court is reading to allow question and answer with the complainant to come down.
Yes.
The whole thing, or just the identity, or the fact, establishing the fact there was a relationship between the two.
The whole thing, I believe, comes in that says that evidence of the statement out there is admissible if it narrates, describes, or explains the infliction of relativism, injury, and complaint.
My argument would be, Judge, this is not right after the incident occurred. Now it's a day later in a hospital. And as a question and answer session, I don't believe that statute would allow this police interview or evidence.
The statute doesn't say it has to be right then and there. In fact, interpret it a day or maybe even 2 days later, you can interpret it as being right after. What we're looking at is whether or not this was determined to be trustworthy. And my understanding is that this witness is in the hospital suffering from a stab wound to the stomach. I would submit that this person would have every reason to want to bring to justice the person who did this to him. So any objections noted?
Except just so you know, there is some discovery here that received it said that he indicated he lied about some information he gave to the police.
Bring out cross-examination.
We have worked here, this witness before it comes in.
No, you have an opportunity to cross-examine.
I would know my objection.
Did Mr. Lipkovich indicate to you how he knew or was related to the suspect?
Yes.
What, if anything, did he tell you?
He told me that they were boyfriend, girlfriend on occasion, that he does his laundry at her house on occasion, that they drink together on occasion, and they're quite familiar with each other. We've known each other for several years.
But he did describe it as.
Judge, knowing what I know about this case, I don't think those are words that would have been used by the complainant. So I would ask that he not summarize what he believed he was hearing, but say exact words that were said.
Your Honor, he is almost verbatim repeating his report.
I don't know anything about this case, or what was said or anything. I'm at a little bit of a disadvantage, but I think it's a fair request that this witness is able to articulate what exactly was told. That's your position that he has. Yeah, let's move on.
Yes, Your Honor, the people would present to the court that he has in fact provided to the court what was told to him. What, if anything, did Mr. Lipkovich tell you happened that caused him to sustain that stab?
Yes, he told me he got stabbed by TT.
Did you clarify who TT was?
Yes.
What, if anything, did he say in response to who TT was?
In the affirmative, the TT is indeed William Turner.
And did he tell you what, if anything, was used to stab him?
I believe he said it was a butterfly.
Can't play speculation. If he doesn't remember, he doesn't remember. Yes,
Officer, did you make any documentation of any of the question and answer that you posed to Mr. Lipkovich?
I did,
Would you have done so on a Detroit Police Department statement form?
yes,
Would you recognize that form if I were to show it to you?
yes,
Would that refresh your recollection as to what Mr. Lipkovich told you?
of course.
All right, permission to approach the witness?
Yes, you were to show. Please.
So is that the statement form that you authored while speaking to Mr. Lipkovich?
Yes,
Please review it silently to yourself and look up at me when you're done. Does that refresh your recollection as to what Mr. Lipkovich told you was used to stab him?
yes,
What, if anything, did he tell you was used to stab him?
butterfly knife.
Now, officer, did you also officer, are you familiar with what a butterfly knife is?
I am.
Could you describe it for me?
It's got a blade that sticks up in the middle, two handles that fold up and around, and you usually clip it together or you can flip it out. It's kind of a knife that flips out.
So with the handle protecting or covering the blade when in a closed position?
to lead it, Your Honor.
Clarification and
Let him
clarification.
describe it, not her.
Is the blade enclosed by the handles?
Yes,
Now, officer, did you also show anything to Mr. Lipkovich while you were in the hospital?
yes.
What, if anything, did you show him?
It showed a single photo.
And what was that single photo of? And why did you have only a single photo of Wilma Turner?
Because after speaking with Mr. Village and determining that he has had a long relationship with Wilma and known her, a single photo is appropriate.
And when you showed him that photo, did he identify the person?
He did.
How did he identify the person?
So that's TT, that's Wilma Turner.
And he provided you with both the nickname of TT as well as her full name of Wilma Turner.
Correct.
And do you see the person from the photograph here in the courtroom?
I do.
Could you please point to this person and tell me something that they're wearing?
Miss Turner sitting there with a white and red t-shirt.
Your Honor,
Objection, Your Honor. I don't. He's not in a position to be able to identify my client. Never seen her before in life.
I'll lay further foundation, Your Honor. So aside from interviewing Mr. Lipkovich, did you do any further investigation in this case?
I did.
What, if anything else, did you do?
I interrogated Wilma Turner.
And when did you interrogate Ms. Turner?
I have to refresh my recollection. I don't remember exactly.
Did you do anything else? Or you know, strike that. What led you to being able to interrogate Ms. Turner?
I was instrumental in locating and having Ms. Turner arrested.
And what, if anything, did you do to lead to that arrest?
I conducted surveillance on her residence.
Did you, do you know if a search warrant was authorized for that residence?
Never had a search warrant.
Were you present when Ms. Turner was taken into custody?
I was.
Did you yourself take her into custody?
I did.
Did you observe it?
I did.
Do you see that person here in the courtroom?
I do.
Can you please point through and tell me something that she's wearing?
Ms. Turner sitting there with a white and red shirt.
Your Honor, the record reflects that the witness has identified the defendant.
So moved.
Your Honor. So when you spoke with Mr. Lipkovich, was it more of a question and answer type of conversation in the hospital, or was it more of a narrative conversation? He gave you a play-by-play of what happened.
It was more of a narrative, conversation, that was broken down into question and answer.
Russell Zane.
Thank you, Your Honor.
Right, is it Officer Stephen Townson?
Correct.
And what was your role in this case?
I'm an investigator in 9th Precinct Detective Unit.
Were you officer in charge of the case at that time?
I made myself the officer in charge of this.
What does that mean?
I arrived on the scene, just following the cutting.
Are you right that you came to the scene itself?
Yes.
And as the officer in charge of the scene, did you take anything into evidence?
No.
Not a single thing. So you never found anything. Never. Did you see? Were you on the fourth or on the second story?
Yes.
And what did you see on that porch?
First.
Other than people, what did you see?
Alcohol.
Tell us about it.
Several beer bottles.
So look as if people had been consuming alcohol.
Correct.
Did you, when you came into contact with Mr. Lipkovich there, did you ask him whether he had consumed any alcohol?
I did.
Ask him whether he's smoking any marijuana?
Did.
Ask him whether he's under the influence of any drugs? Did you get close enough to talk to him?
Of course, yes.
Did you smell alcohol coming out of his breath?
I did not.
Did you, all right, you told us you didn't take anything to evidence at that point. And then later you went to the hospital the next day, is that correct?
I believe it was the next day, yes.
And why did you do that?
To interview.
Okay. Did anybody else come with you?
No.
And how did you know where he was?
I knew he had been transported from the scene to receiving hospital. Went to receiving hospital, asked the security what's room.
And you were by yourself, is that correct? Did you have a recording equipment with you?
I did not.
I'm sorry?
No, I did not.
All right, so you had no body cam with you?
No.
So there's nothing to confirm here that you at all, other than
my word.
How about notes? You take any notes?
I did.
Handwritten notes?
We recorded on the state.
I'm sorry?
I took a handwritten statement.
No, handwritten notes is what I mean.
No.
I mean, all that's been presented is 2 pages of maybe 3 or 4 questions and answers. There's no other written documentation of your interview?
No, sir.
How come you didn't have a body cam?
I usually don't take the body cam.
How come you didn't have any recording of this?
That's a good question.
Are you familiar with any police regulations that require you to?
Well, typically, we don't take a body cam into the hospital setting.
Okay. So somebody's in the hospital, as you knew, a victim of a stabbing to his stomach, is that correct?
Correct.
Okay. Did you consult with any hospital staff, whether it be doctor, nurse, or anyone, as to whether Mr. Lipkovich was under the influence of any medications, such as painkillers or anything of that nature?
No.
And why didn't you do that?
assessment for myself.
Wait, are you a doctor? Do you have any kind of medical license? Well, it's not a silly question because you said you made assessment for yourself, but did you look in your self-assessment at any charts?
No, sir.
Regarding him? So you don't know whether he's under heavy influence of medication at the time, based on any kind of investigation?
In my experience, being a human being, I was able to tell that I'm having a reasonable conversation with this man. It was lucid and, you know, poignant. So, I mean, if it was off the wall, hey, I'd have stopped. You know, I got pretty good judgment as far as that goes. But he was able to tell me what he was able to tell me.
So how did the interview start?
Just lay the foundation of,
But I don't need a summary. I mean, what did you say?
I
don't remember. And that's a little problem here because we have no video as to that part of the conversation.
But we have good statement.
Yeah, you just told me you didn't remember what the first thing you even said.
I probably said hi.
All right. Now, you already testified that part of the information that he gave in response to questions, is that right?
Yes.
But there was a little bit more, isn't that correct?
Yeah.
All right. For example, from what you did write down that I could see, you asked him, do you think she was trying to kill you? Remember that question?
Yes.
And did he say no?
I'm not sure what his statement is.
Did you look at this before you took the witness stand?
No, I did not.
Good. What, sir?
So what you call me, stupid or something?
No. Just asking questions. Did you ask him, do you think she was trying to kill you?
Yes.
And did he say no?
Yes.
Thank you. Now, you said that you came into contact with Miss Turner?
Correct.
And when was that?
It was the same day as the statement from Mr. Whitman.
Well, you talked to him 2 different weeks, so would that have been the August 21st or August 22nd?
22nd.
Where did you come into contact with her?
We're on Berkshire Street.
Well, you already told us you didn't come into personal contact with her, is that right?
I saw her.
Right, you didn't arrest her.
I didn't physically arrest her.
Right. And
I ordered the arrest of her.
Where were you when you ordered?
I was standing on her front porch.
So she came out the front door and
she came from across the street.
All right. And you guys were in police uniforms, is that correct?
I was not.
Other people with you, right?
Correct.
All right, so then, where did you have her taken to some location?
To the Detroit Detention Center.
Okay. And did you go to that location?
I did.
Okay. And did you go there by yourself?
I did.
And what was your intention of going there?
To interrogate the woman.
Did you fill out any paperwork before you interrogated her?
I did.
What was that?
Nice rights form.
Any other form you utilized for biographical background?
No, I don't think I took her.
Did you say anything to Ms. Turner before you gave her Miranda rights?
No.
You didn't tell her why you were there, what you were doing, what your purpose was?
Yes.
But that's what I'm asking, officer. What did you say to her before you gave her?
I don't recall it.
Okay, I'm ready for the question, Chair.
You redirect?
No, no redirect, Your Honor.
Thank you, sir. You may start.
I do have one other question. I'm sorry. Isn't it true that did she tell you she denied the incident?
Yes.
Stamping?
Yes.
Thank you. Nothing further.
Your Honor, may this witness be excused?
Yes.
Your Honor, may I have a moment, please?
Yes.
Thank you. Your Honor, at this time, the people would like to place on the record that the people and the defense have stipulated to the identity of the decedent for the purposes of preliminary examination, that his identity is Cliff Finch.
What I agreed to stipulate to is the identity of the person who was in the hospital, that was the subject of the autopsy.
Proceed with stipulation.
Thank you.
And then people would seek. People in defense are also stipulating for People's Exhibit 2, which is the medical examiner opinion, which was performed a postmortem examination on the body of Cliff Lipkovich on August 25th, 2023, Your Honor.
Your Honor, we provided a document for the hearing marked, which is now marked as Exhibit 2, that includes not only the autopsy report, but also the toxicology.
That is accurate. It does also include the toxicology.
So I have no objection to admission for exam purposes.
Amen.
The autopsy was conducted by Dr. Lokman Sum, the interim chief medical examiner of the Wayne County Medical Examiner's Office at the time. He opined that the death was caused by a stab wound to the abdomen with complications. It was reported that the decedent sustained a stab wound to the right abdomen. At the hospital, he wound found to be tachycardia and hypertensive. There was evisceration of the ilium and bleeding into the posterior rectus of sheath of the abdomen. During surgery, the loops of the small bowel were reduced and bleeding was coming from the abdominal wall. Overnight, there was persistent worsening, tachycardia and hypertensive. The decedent was guarding his abdomen and it was diffusely tender. A computed tomography scan of the abdomen showed some small bowel dilation concerning for developing obstruction. He was intubated with respiratory support, and it was thought he aspirated fire during intubation. And since intubation, he has had developing hypoxemia and developing septic shock. On autopsy, there was a stab wound to the right middle abdomen. Of note, the wound was surgically explored and stapled externally and sutured internally prior to postmortem examination. There was a healing bruise surrounding the wound. The wound tract proceeded from his injury through the anterior and abdominal wall. There was bleeding within the mesentery, possibly surrounding the stab wound. The wound track was from front to back and right to left when the body is viewed in the standard anatomical position. The manner of death is homicide. Your Honor, this time the people have asked me no further witnesses.
Any witnesses for the defendant?
No, Your Honor.
This time the people move for bind over and will reserve argument for rebuttal.
Depends what the objective bind over here, Your Honor. Charge tends to be shown to the level of probable cause of all the elements of second-degree murder. Intent to kill, do grave bodily harm or act of wanton disregard. The court knows the classic definition of second-degree murder. Obviously, not all homicides are second-degree murder. Some, upon given certain mitigation on a court record, such as we've had today, can reduce the charge to manslaughter. In this particular case, I think a few things are clearly established. Is the fact that Ms. Turner and the deceased were in a relationship. I think that was established a number of times by the prosecutor. We know that this isn't one of those cases where there's somebody had a beef or a motive to take someone out or a plan to take someone out or kill them or something like that. This is a case that probably shouldn't have happened, a situation that was spontaneous. We know that because, again, there were a relationship. There may have been some alcohol involved. The last officer provided an interesting scenario showing there were a lot of empty beer bottles there at the location. But anyway, that we know through a question of the first officer who testified, Officer Jackson, that what limited information, I think it was Stefan Jackson, that he was able to provide to us because Mr. Lefkovich said he really didn't want to speak because he was in pain, but he did say that he and the offender had a verbal argument. So we not only know it's within the context of a relationship, but also there's a verbal argument that preceded the single stab, and that leads up to my second factual argument. There was a single stab wound to the body. So it's not one of those situations like People versus Hoffmeister where there was multiple stabs to the People versus Hoffmeister, was what I'm referring to, a Michigan Supreme Court case. This is a single stab. So the court can consider that in terms of the context of this was followed a verbal argument and a impulsive action on the part of the person who is claimed to have done this, Ms. Turner. The last very important factor that I would argue to this court is we know that the last officer who testified went to the hospital the next day to interview Mr. Lefkovich to derive whatever important information he'd like. And obviously he showed the photograph of my client that was identified by Mr. Lefkovich. But one of the important things that I would like to highlight to you is a part of the interview that the prosecution chose not to bring out that I did, which said he was asked by the officer, do you think she was trying to kill you? And Mr. Lefkovich, who knows Ms. Turner, who knows the situation that occurred, and assessed what happened to himself.
It just addresses one of them.
He said no.
Second.
Right, he said no. The important thing is
the intent to kill, but there's also another problem that the court can consider whether she created a high risk of death or great bodily harm.
Yes, I understand that by itself. But that's why I was highlighting to this, the context behind this was a verbal argument between the parties and a single stab. So there is some mitigation, I think, on the record in terms of how this occurred, an assessment by Mr. Lefkovich that she was he didn't think she was attempting to kill him. You can conclude from all that as I argued to the court that If there's a bind over it, the appropriate bind over would be voluntary manslaughter as opposed to second degree murder. There's just no reason for this to have happened. And between people who, care for each other, there's a verbal argument involved. So we think there is some mitigation that would allow the court to bind over on charge of voluntary manslaughter. Thank you.
So, Your Honor, the elements of second degree murder are as follows. The defendant caused the death of the decedent. So, Ms. Turner caused the death of Mr. Lipkovich. We have testimony that Mr. Lipkovich repeatedly identified Ms. Turner as being the person who stabbed him. The People's Exhibit 2 indicated that the manner of death was homicide via a single stab wound to the right abdomen. Therefore, that is the first element met by the people. Second, that the defendant had to have one of the following states of mind. One, that she intended to kill, that she intended to do great bodily harm, or that she knowingly created a high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her action. Now, we can take into consideration a couple of things here. One, the fact that the complaining witness indicated, well, no, I don't think she intended to kill me, does not negate any potential intent that she could have had. It's his opinion. And as Mr. Cripps pointed out several times, they had a relationship. Absolutely no one wants to look at someone that they had or have a relationship with and say, yeah, that person wanted to kill me. So I don't think that that holds as much weight as Mr. Cripps says that it does. However, we can take a look at what was going on. There was an argument, a verbal argument, and she, out of the blue, pulled out a knife and stabbed him in the right abdomen so specifically, so harshly, Your Honor, that as you can see, the People's Proposed 1, there is bowel and intestine hanging outside of Mr. Lipkovich's body. That act in and of itself indicated where she stabbed him, the force, both entering and exiting, was enough to cause an injury of great bodily harm. Having your intestines pulled from your body is great bodily harm, and stabbing him where she stabbed him was intentional. And stabbing a person in that location, in their bowels, in their intestines, shows an intent to cause that harm, that she should have known that harm or death could result of such a stab wound. I think people have met their burden, and that Your Honor should not reduce the charges to manslaughter, because we have met every element for second degree murder, because Ms. Turner did engage in intentional acts, stabbing him in the abdomen, causing an injury of great bodily harm. And I would ask that Your Honor bind over as charged.
So my role is not to determine whether or not there is another crime here that fits better. My role is to determine whether or not people have met its burden with each and every element of the crime that's charged here. The crime that's charged here is second degree murder. There's no question as it relates to the cause of death, or the defendant caused the death of the complainant, Mr. Lipkovich. I don't think there's an issue for probable cause purposes as to the identification of the defendant as being the person who caused the death of the complaining witness. As far as the intent that was done here, even if I was to go by the alleged assertion of Mr. Lipkovich that he did not believe that she intended to kill him, I submit to you that's just one of the prongs that the court has to find. One of the three states of mind, either intent or assault with intent to do great bodily harm, or creating a very high risk of death or great bodily harm, knowing that death or great bodily harm would be the likely result of those actions. And I submit to you that stabbing someone in the stomach to the point to where their guts are hanging out creates a very high risk of death or great bodily harm, at least for probable cause purposes. Again, my role is not to determine whether or not a more suitable charge of manslaughter would fit here. It may very well fit here, but that's a question of fact to be determined by the trial. The court is satisfied that people have met their burden of probable cause as it relates to the charge contained in the complaint. The court finds that charges committed in the city of Detroit. The court finds probable cause to be listed. Then it will be bound over to Wayne County Third Circuit Court Criminal Division for further proceedings. Her arraignment with the information date and time will be June 18, 2024 at 9 o'clock a.m. Are there any issues as to bond?
People just ask what the bond is currently, Your Honor.
I think the bond was originally 500,000 cash, surety 10% GPS teller. What is the bond now, Mr. Brooks?
I'm trying to look through my notes here, Your Honor.
That was the last bond that I had written down, Your Honor. I just wanted to confirm.
I believe that's what it is, Judge. And she has had no bond violation whatsoever. She doesn't reside in that area anymore. She,
Is it with just tether or tether and house arrest, Your Honor?
she's been in and out of the hospital. She has very strong family support here. One of her daughters takes constant care of her. I don't think there's no chance at all that she would ever miss a court date. She's not a danger to anybody because she's home. Yeah, she's on home arrest too. We've had a number of requests that she fully complied with, such as we did have this court may remember competencies and trial evaluations done. She's been fully cooperative with every doctor that's evaluated her. By a doctor at the forensic center and at the independent doctor.
People aren't arguing anything about bond, we just confirm that we have the most up-to-date accurate bond.
Which is what?
It appears to be 50,000, 10% cash surety.
50,000, 10% or
500,000, I'm sorry, Your Honor. 500,000, 10% cash surety, GPS tether house arrest.
Are you on house arrest?
Yes, sir.
Oh.
Leave except for medical and court is what I showed
you.
Thank you very much, Judge.
Y'all can read the phone.
I know what the medical team. Yeah, sorry. Mr.
What's that?
Teresa Williams.
Come on up, Miss Williams. People, I have your exhibit.
Permission to approach to retrieve, Your Honor.
This way. What's your name on it? Teresa Williams. Teresa Williams. Yeah, thank you for coming down this way. How you doing? Everybody can see you. I see my chair.
Oh, right.
Look, everybody, we got Felicia Williams with us. Came down to the court to visit.
Straight to. Hi, everyone.
Thanks for coming down. That concludes the docket for today, folks. Hope to see you tomorrow. Same bad station, same bad time. Have a good day now.